estate planning presentation. And so our speaker this evening is going to be Jeremy Graber. Jeremy is an attorney and partner at this Folston Steepkin law firm, and he is in their office here in Topeka. Jeremy practices in the area of estate planning as well as other things. He is also involved in scouting with his kids in Lawrence. And he's also a past Eagle. He is an Eagle Scout and a 20 under 40 honoree. So with that, I'll let Jeremy take it away. When he's done, I'm going to make a few comments with some information about the endowment when he's finished. And so we'll go from there.
And just to let everyone know too, that this is being recorded. So for the people online too, this presentation is being recorded, and Jeremy has allowed us to share this out beyond this meeting too.
Thank you, Vince. Thank you all. As Vince said, I'm an Eagle Scout. I grew up in Kingman, Kansas, which is a small town down by Wichita. Got two boys in scouting. My oldest is now a Life Scout. My younger boy has just got his Arrow of Light. And so I've been Cub Master for a while, and I'm graduating from that and looking forward to maybe a different role other than Cub Master. But today we're going to talk about kind of some estate planning. And this, I'm not going to talk for 2 hours. I could talk about this topic and answer questions for hours on end. It's interesting to me. I've helped lots of families both before and after death with all sorts of different issues, disputes, some things that we try to avoid disputes, but this is to kind of give a broad overview of what is estate planning, what is it not. And I'm going to ask Wayne to kind of help with the slides down there. You've got a copy of them. This will kind of help me stay on track so I don't start rambling too much. But if you have questions, please ask. Those of you online, I can't see you, but feel free to ding Wayne over there running the program. So Wayne, if you want to switch over to the next one there. So here's kind of our general plan today is we're going to talk about just what is basic estate planning and to kind of help understand what is the process. Some folks, every time I look at various studies, 60-some% of people do not have an estate plan. And that does not surprise me, at least from the people I deal with and clients I serve and families I help with after death. I'm hopeful that this will give you an idea of what is planning, and it's not a big scary thing to go talk to a lawyer and be a little bit more informed to do so. Then we're going to talk about some beneficiary designations and probate versus non-probate, some simple gifting strategies to maximize effect. And part of why we're here is the Scouting Foundation. So how can we support the foundation or other charities in a more tax efficient manner than simply writing a check out of the checkbook? And then last topic, if we have some time, some common pitfalls I see in the planning process and plan giving. All right, go ahead, Wayne. So the first basic estate planning 101, you all sitting here have an estate plan, whether you know it or not. So if I ask, do you have an estate plan? Everyone should raise their hand, okay? Kansas law, if you die without a will or anything else, Kansas law dictates where your property will go. And in Kansas, it's 1/2 to your spouse and 1/2 to your children. And you may be thinking, oh crap, I can't believe that. But that's what Kansas law is. If you are married with children, even if that child is 6 months old, that child inherits half of your assets. And that's an equal and undivided portion. So you have the house, maybe you have the 40 acres out in the country, maybe you've got the vacation home, maybe you've got the RV. They get half of that, the spouse does, and the kids get the other half. You have adult children who are married. Guess what? In Kansas, real estate, whether you own it with your spouse or not, it's as, and I like to explain it, it's as if the spouse owns it too. So if you have adult children who are married, now you've brought in all of their spouses. So I've seen this happen many times. Someone passes away without a will, leaves all the assets to the 4 children. Maybe they're not married at that time. The 4 children are all married. So if you want to do something with that land, that takes 8 signatures. 4 children and 4 spouses. Come on in. So intestacy, we sometimes have to deal with it, but let me just write down here on the other slide. I call it the do nothing plan, because it is the plan that is set forth if you do nothing. So we want to avoid intestacy. It's a hassle, it's expensive, it never carries out the party's intentions in my experience. Even if it's because it's more difficult to get the assets to the people you want. If you're single and you have 3 kids, intestacy says the 3 kids get it, but you have to go through the court process and it's a hassle. The other reason to do basic estate planning is if you have minor children. Historically, until recently, you had to name a guardian or conservator for minor children in your will or trust. Kansas law changed this year, I think, January 1 of 26, that it could be, I think, any instrument, which is a bit vague. When I'm talking with the 40-year-old couple who has a couple of children and they say, Jeremy, do I need an estate plan? And I say, my concern is not necessarily your assets, but who is going to take care of your minor children. And so even if we just do a basic will, we want to make sure their guardians or conservators are appointed there. So go over to the next slide. What are some common estate planning documents? Any of you that have been through estate planning process, this may seem very basic, and I apologize, but I come at this as starting at the very bottom and we work our way up. So the common estate planning document, you have a last will and testament. A lot of people know what that is. It's a will, last will and testament. Those are about the only 2 terms it's called. Next, come on in. We have a revocable trust. Sometimes it's called a revocable living trust. Sometimes it's called an inter vivos trust. I don't know how to pronounce it. I don't think anybody knows how to pronounce that, but it has all sorts of different names. The point is it can be changed at any time during your life until the point that you're disabled. There are also irrevocable trusts. Irrevocable means cannot be changed. I'm not talking about those today. That's a little bit outside the scope of this presentation. Typically, we deal with those for 2 reasons. One, really wealthy people and we're avoiding estate taxes, or we're doing Medicaid planning. And you're wanting to set up a trust to avoid spending all your assets going into the nursing home and to accelerate Medicaid qualification. I don't do Medicaid planning, but that's the gist of why you might be thinking about an irrevocable trust. Lots of money for getting on Medicaid. Next, powers of attorney for healthcare decisions and financial decisions. Sometimes these are called a durable power of attorney. That's all a similar, people use different terms, but that's the gist of what we're talking about here. Is someone who can, if you are typically disabled, someone who can make decisions for your healthcare needs or your financial needs. I've put underneath there springing versus non-springing. Springing means it springs into existence upon an event, typically disability. So my power of attorney says I appoint my wife as my agent for healthcare and financial decisions. She only has authority upon my disability. So depending on the form, 1 physician or 2 physicians have to sign off saying this person's disabled. Then that person can sign on your checkbook or make a treatment decision. These come in different forms. In my law firm, we have a healthcare power of attorney as one document. We have a financial power of attorney as a separate document. That's our approach because sometimes people want one person making financial decisions and somebody else making healthcare decisions. I have seen plenty of forms that say, I nominate Wayne as my healthcare and my financial agent, all in one document. I'm not saying one is right or wrong, that's just our approach. Whether to do springing or non-springing is a personal choice. I typically tell the story of my grandfather who got Alzheimer's and dementia, and you've probably seen it in some of your family members. He would have a good day in the morning, knew what was going on. By late in the day, he was confused and probably did not have capacity. So at what point does that springing power of attorney come into existence? When are they able to make those treatment decisions or those financial decisions for him? And, dementia is a nasty beast and it's a decline and ups and downs. So with my older clients, and I use that term older loosely, I typically encourage them to use non-springing. Because typically when you need to make a decision, whether it's a treatment or a financial decision, do you want to have to spend the time running to the doctor to get two people to sign off that yes, mom or dad is disabled and the spouse or the child needs to make that decision? For my 40-year-old clients who are leaving town for the first time without the children and going on a spring break trip and leaving them with the grandparents, typically we do springing, again, effective on disability. The fourth bullet point there is a living will, sometimes called an advance directive. This is an instrument that says if you are terminal, you have a terminal condition as certified by two physicians, that you're not coming back, that you direct an advance directive that life-sustaining measures stop. This means no, take me off the ventilator, don't give me the feeding tube, or take it out and let me go. There's some variations. Do you still give them water or not? Do you give them food or not? That's a little bit too far in for this discussion, but that's what that document is. Not to be confused with the fifth bullet, a do not resuscitate, also called a DNR. DNR is if you have a heart attack and the ambulance comes and you want the paddles to jumpstart your heart, a DNR says don't do that. Okay. I don't prepare DNRs. Some estate planners do. I encourage them to talk to their primary care physician about that. Partly because I think a DNR and living will are often confused with one another. But a DNR is typically, you see that in a lot of elderly people in a nursing home. I hate to be crass, but sometimes that's where I see them most common with my clients. So those are what I call the general estate planning documents. They have different looks and styles across different people. You can find lots of versions online, actually. So let's talk next about how we can transfer property at death. You want to go to the next one there, Wayne, for the folks online? There's lots of different ways that you can give property to other people when you pass away. And this is probably not an exhaustive list, although I've tried to list the most common manners. And this is kind of dovetails with the next slide as well. So joint tenancy with rights of survivorship. Most married couples have their house in joint tenancy. You probably don't even know it. You bought your house, you went to the title office or the bank, and joint tenancy. One of the joint tenants dies, the other owner gets it automatically. You file a death certificate, they own it. Just as easy as a beneficiary designation, pay on death designation, transfer on death designation. All of these are different terms for the same concept. I own the bank account in my own name. I have a POD designation on file with the bank. I die, the POD designee gets it. You have a 401k or an IRA, life insurance, you have a beneficiary designation on there. Pass away, the beneficiary submits some claim forms, turns in your death certificate, they get the assets. Almost all assets under Kansas law can fit in one of those two buckets. I'm not saying that's the right approach, but it's an approach. Next, we talked about the revocable living trust. At death, any asset that's in that trust goes to the trust beneficiaries. Some trusts say, at my death, all assets in the trust to my spouse. If my spouse is not around, to my children. And last is probate. And there's two sub-bullets there. You have a will. The assets go in accordance with your will. All assets to my spouse. If she doesn't survive me, to my children. All assets to my spouse. If she doesn't survive, $100,000 to the Boy Scouts, the rest of my children. That's in a will. Intestacy, we talked about this. If you don't have a will, or you have a loose asset out there that's not covered, intestacy. Here's a quick story. I had about 12 to 15 years ago, a younger person passed away. She was single. She had a will that she had, and no children. She had a will that she had found online or something. And I don't know what software, but it almost seemed like she walked around her apartment and said, the TV, the couch. I mean, she had a simple plan, but it listed, A through Z of assets, including the car and the bank account and whatever else. But it didn't have a residuary clause. It didn't have a clause that said anything else to whomever. So this person passed away. She actually fell on a mountain, if I recall. And so all the assets A through Z were under her will, but we didn't have a residuary. So everything else, because she missed a couple of bank accounts that weren't specifically listed, were under intestacy. So when I have a person pass away, we may have assets in each of these buckets. Okay, some of you may have a house that's in joint tenancy. You may have a 401k or IRA that has a beneficiary designation on it. And you may have a basic will. So each of those buckets are how the assets can be transferred after death. Again, none of this is right or wrong, but these are just mechanisms for getting it to the right place. So if we go over to the next page, order of priority. And really 1 and 2 are kind of, I could combine them. But if an asset is owned in joint tenancy, it doesn't matter what the will and trust says. The joint tenant gets the asset. If your IRA has a beneficiary designation on it, that beneficiary gets that asset. And we'll talk about this later. Sometimes people get confused. Well, my will said I wanted all my assets to go to the Humane Society or to the Boy Scouts or to my children. I didn't want anything to go to somebody else. Yeah, but the beneficiary designation said differently. So when I have young people who are married recently with children, I say, that John, you've been working at Cap Fed for 10 years and you're on their 401k plan. What's your beneficiary say? Oh, it says my mom and dad, or it says my brother. Well, now you're married with children and it still has your brother or mom and dad. Older clients, well, they were divorced 20 years ago, never changed the beneficiary on the life insurance. Or newly, maybe widowed and newly married. Again, did you update the beneficiary designations? People forget, kind of on this slide here and the one before, assets are in different buckets. Don't forget that if you're kind of looking at what are we trying to accomplish here with our estate plan. For me personally, I often, when I have new clients who I haven't worked with before, I don't talk about their specific assets. I talk about their goals. What are we trying to accomplish here? We're trying to get some assets probably to the spouse, then to the children, take care of the charity, maybe the grandkids. If they're not married and don't have kids, maybe it's other family members. But what's the goal? Let's start there. And then we will look at the buckets, where the assets are titled and how they're owned. Because I can put together a 50-page trust document, but if every single asset is in joint tenancy, that trust document is useless. So that's, don't be so quick to discount some of the plan. All of you are already doing planning, whether you know it or not. I tell people who start a new job, did you fill out a beneficiary form? I don't know. Well, you sat there with HR for an hour and filled out a bunch of forms. My guess is you filled out a beneficiary form for the company-owned life insurance. My 50-year-old go, oh, I don't know. It becomes one syllable. Oh. Any questions so far?
Oh.
Oh. All right, very briefly, taxes. Everyone's favorite topic this time of year. So most of us are very familiar with income taxes. There is a different set of taxes called estate and gift tax, sometimes called death tax, sometimes called inheritance tax. Right now, unless you are worth $15 million each, which means for a couple who's doing collective planning, $30 million, your beneficiaries will not pay any estate tax or death tax. I had a potential client I talked with this morning, or this afternoon, excuse me. He had was buying a couple pieces of land, and round number, I would guesstimate just from our call that he was worth less than $5 million. The bulk of the conversation was he wanted to avoid his children having to pay death tax. I said, buddy, unless you win the lottery, your kids aren't going to pay estate tax. And this topic of $15 million, which is higher than it has been in history, but even this can change with Congress and the president doing something, but we can only plan with our current laws. But most folks are not subject to estate tax. You can give, the other part of this is, some people think of this as the $10,000 rule or the $15,000 rule. It's now $19,000. You can give $19,000 per each donor to each donee without even worrying about gift tax. So I could give $19,000 to everybody in this room and there's no gift tax issues. For most people, that's not an issue either.
That's per year?
Per year. So my high net worth clients, they are doing a planned gifting program. It's not really a program, but every year they write a $19,000 check to each of their children and grandchildren, children's spouses and grandchildren's spouses, because they are trying to reduce their estate to reduce estate tax without using up some of their exemption. Next important tax topic is basis. So if you buy a stock for $10 or you buy a piece of land for $100,000, that's your basis. If you sell it, the difference between your basis and the sales price, you pay capital gains. Okay. If you die, you get step up in basis on that piece of property. So if you have a $100,000 piece of land, you die and it's worth $300,000. Your beneficiaries take it at the $300,000 level. That's called the step up in basis. They sell it for $300,000. They don't pay tax. So the day before you died, you sell it, you pay $200,000 of capital gain tax. Your beneficiary or heir sells it the day after you die, they don't pay any tax. So step up in basis is a significant planning topic, especially for my farm clients. IRD stands for income in respect to a decedent. This is an IRA 401k topic primarily. It's an asset in which the decedent pay income tax. Decedent is a fancy word for a dead person. I one time had somebody ask me that question and I felt embarrassed that I didn't explain that before, but. So a decedent is a deceased person, dead person. So if you are deferring money into a 401k plan, you haven't paid income tax on that. Your heirs will pay income tax when they take it out. There is no step up in basic on IRD money. Now, what's confusing? Well, Jeremy, what about a Roth? A Roth is different. You already paid the tax when you put the money into the Roth. So everything coming out of the Roth is not taxable to the beneficiaries, assuming you comply with all the IRS rules. I have given a presentation on IRAs and I talked for an hour about that. So I'm going to leave IRAs at that for now. Any questions on tax? I know taxes are really confusing, but these are the main tax topics when we're dealing with estate planning. When I have a new client come into the door, I ask them, are you worth $15 million or more? They say no. I said, okay, let's not talk about estate tax. But what's important about, especially the next two buckets, is when we talk about giving to charities. So the next slide here, how do you leave property? And this could say to charity or a person, but how do you leave property to charity? You know, I want to leave some money to the Boy Scouts or United Way or the Humane Society or the Red Cross. Almost any of the features we've discussed before, you can add a charity to that instrument. So your bank account, you can add a charity as a POD beneficiary. Your IRA card, you have an IRA at whatever institution. Right now, it may say 100% to my spouse, and the contingent beneficiary says 50-50 to your two children, right? Instead, you could say 100% to the spouse, and then a third, if the spouse doesn't survive, a third to the charity, and a third to the other two kids. All perfectly fine. Those are personal decisions. And taking one step back, you have no obligation to leave any money to your children. Believe it or not, you can leave all your money to anybody you want. They are not entitled to a nickel. They may think they're entitled to it. And I bet if we asked them, they would think they're entitled to all of it. But you don't have to ask them. And on that topic is, do you talk about your estate plan with your beneficiaries? That's a touchy one. We'll talk about that in a minute. But so the IRA, et cetera, you can name the beneficiary on the card. You have a trust. The trust says, I give, off the top, I give $100,000 to these 4 charities. The rest and residue I give to my spouse or the kids or my nieces and nephews. The same with a will. I give $100,000 to these 4 charities. I give the rest and residue to these other people. I give 10%. I give 20%. Those are all options. I made a note here, consider using an MOU, Memorandum of Understanding, with a community foundation. I've done some work here with the community foundation. And so the way the document reads, like a trust, I give $100,000 to the Topeka Community Foundation to disperse to those charities listed with an MOU I have on file with the foundation. So then, people don't like to pay lawyers, right? We're really expensive. It's a pain. It's nerve-wracking. But we get the trust set, then you can go change the MOU with the foundation anytime you want. You don't even have to call the lawyer. You just say, hey, I want to change, instead of giving 25% to this charity, I want to give 50% to that charity. And then you don't have to change the will or trust.
Jeremy, we have a question.
Yeah.
If it's okay. John Gray wants to know, if we gift 100,000, do we need to pay gift?
There is no gift tax for charitable payments or gifts. So on the prior slide, I had 19,000 per year is the gift tax exclusion. Charity is unlimited. Spouse is also unlimited. So you can give $100,000 to the charity. You don't have to report it. You don't have to, it's totally excluded. And that's during life. For a gift, that's during life. And at death, you can give as much money as you want to charity as well. The last in brackets, not intestacy. If you want to give money to charity, you have to take some overt step if you want to leave money to charity. Because intestacy is driven totally by familial family lines. All right, some simple gifting strategies to save taxes. This is not a complete list, but here are a few tools to consider. If you leave an IRA, annuity, or other IRD asset directly to the charity, nobody pays income tax on that. How do you do that? You put the charity on the beneficiary card. This is a lot of clients, as we have moved towards the utilization of 401k plans and gone away from pensions. And my senior partners, they grew up in the times that you had a pension, you had the house, and 40 acres. Now we have these IRD assets that have never been taxed and don't get step up in basis. So how do we want to support the charity, but I really don't want to have to pay income tax. So let's give you a hypothetical. You have $100,000 you want to give to the charity. If the trust says $100,000 to charity, you give that to the charity, there's no tax, that's fine. But your IRA says equal shares to the two kids. Well, your kids, when they draw out that $100,000, they're going to pay income tax, right? Instead, send $100,000 from the IRA to the charity and just give all the other assets to the kids. Now the kids aren't paying any of the tax on that $100,000. Charity still gets its $100,000. They don't care either way. But you just saved your kids. And if they're paying in the 20% tax bracket, that's $20,000 that's not going to Uncle Sam and back in your kids' pockets. Some people say, well, Jeremy, I'll just put the beneficiary as the trust, and then I'll have the trust pay the charity. No, does not work. The charity has to be the beneficiary on the IRA. And I've made a comment here, coordinate beneficiary designations with pledges. That is really hard to do. Financial institutions, they want to know who the person is and a percentage. They don't want to say, well, if I haven't satisfied my pledge, then take it out of the IRA. Some of them are more flexible than others. That's the simplest thing to do at death. Leave an IRA or 401k to a charity. But during life, donate low basis assets directly to the charity. You bought the stock for $10, it's now worth $50. You can sell the stock and pay $40 of capital gains, or tax on $40 of capital gains, and give the charity the $50. Or just give the stock to the charity. Charity sells it for $50, no tax. So I have clients that have, they worked at AT&T 40 years ago, and they have some stock. And they've been supporting Washburn or the Boy Scouts or the Humane Society for 10 years. But they're tired of paying capital gains. Every time they sell AT&T stock, they got to pay Uncle Sam. I say, just give them the stupid stock. It's that easy. The same with the next one. Qualified charitable distribution. This came around about 10 years ago. A lot of clients are doing this now. You have to be 70 and a half. The max is $100,000 per year and it's indexed. So I think it's $110,000 or $15,000 now. I'm not sure. But instead of taking $10,000 out of the IRA and then giving $10,000 to the charity, remember, you take the $10,000 out of the IRA, you got to pay some to Uncle Sam, right? And if you're over 72 or 3, depending on when you were born, you're having to take RMDs, right? So now, instead of taking the 10 and paying tax, you tell the IRA, send $10,000 to the charity. So number one, you don't pay tax on the $10,000. And two, you don't have to take the RMD. So that is a significant benefit. And even from what I'm hearing from my clients, even the smallest rural churches are able to take a QCD. And most of the IRA custodians are happy to do this. That it is not difficult at all. So I know most people are used to dropping a check or whatever in the plate at church, but using a QCD is much more tax efficient and not very difficult to do. The last bullet, there's a lot more convoluted ways to give money to charities, but it's complicated. And unless you're on the prior screen, over $15 million, most people aren't doing any of this kind of complicated charitable remainder trust, charitable lead trust, conservation easements, and other. I guess it's on the next page, on the next slide. These are convoluted, complicated. I don't like to do them. You have to set them up very carefully. You're kind of playing, you're either giving the charity the money during your life, and then at death, the difference goes to your children in typical cases, or vice versa. The children are getting an annuity stream for a period of time, and the charity gets the remainder. That's why they're called lead trust or remainder trust. Does the charity get it now or at the end? Donor advised funds are growing leaps and bounds. Anybody can set up a donor advised fund. You can do that with most community foundations, Fidelity, Vanguard, they all have an arm that's a donor advised fund. Well, what is it? You put $50,000 as an example into a donor advised fund. That is an income, or that is a current year charitable gift to that donor advised fund. But no charity has actually received it. It's just a fund. So now next year you can take $50,000 and you can give $10,000 to that charity over there. And then maybe the next year you give $5,000 over there. And so it's, some people call it a poor man's private foundation. It's when the laws changed with the itemized deductions a couple of years, a lot of people were using a donor advised fund to front load several years worth of donations. So every year you gave $5,000 to the church and Boy Scouts and the Humane Society. Well, maybe you put $25,000 into a donor advised fund in year one, take the charitable deduction, and then you pay out $5,000 over the next 5 years from that fund. Technically, the fund does not have to follow your wishes. It's donor advised, not donor directed. That's because of the IRS rules. It has to be a gift that you no longer control. There was an article in the Wall Street Journal a couple months ago about an individual who passed away with a large donor advised fund, and the children were the successor advisors, and the charity didn't want to listen to their input, and they were all mad about it, and they couldn't believe it. No, that's a risk, I think, with these funds. At a local level, I haven't heard that whatsoever. I think if the sponsors of those donor advised funds stopped taking the advice from the donors, they would stop having people contribute to them. But I want to point that out because I think some people are using them to, wealthy people are starting to use them as to basically grow an endowment or create what should otherwise be a private family foundation. They're just cheap and they're wanting to use a donor advised fund, and they can get burned on it.
Does that fund earn interest by any entity?
It is growing in value, yes. So if you invest with or you create a donor advised fund with Fidelity, that $50,000 in my example is being invested in, I don't know the particular, but yes, it is supposed to grow in value.
And then does that then go back into the donor advised fund?
Yes.
Okay.
So that $50,000 might go to 60 or 70. And yes, that can be used to sprinkle the various charities,
At that.
anytime. Because when you put the $50,000 into the fund, that's when you've made that gift.
Okay.
I haven't seen it yet, but I'm expecting at some point to start having to deal with clients who created a donor advised fund, but didn't establish any mechanism for who takes over when they pass. I've had to deal with that with 529 plans, college funds. Somebody passes away, they had a fund for their grandchildren. They didn't name any successor person to manage that. But when you create a donor advised fund, I believe you can name who takes care of this if I'm not able to. And again, this can get really complicated. So I encourage people, let's not get too complicated. Okay, the next topic. We're about to wrap up here with a few things. Should you gift to charity at life or at death? During life or at death? That's a complicated question that there's not a correct answer to. I often tell clients, do you want to see your charitable dollars being put to use? Do you want to see the Boys and Girls Club build a new playground? Do you want to see the hospital build a new wing or whatever? Then you ought to do that during life. I often tell people it's often a good training to see if the charity is going to do with your money what you may want to before you give them a whole bunch later on. Some people say, I'm just going to spend it all and not have anything at death, so it doesn't matter. And then the best one is the talk. Well, I told my kids what I want them to do with the money, so they'll do what's best. And I say, okay, that means they're going to keep it all and spend it. Oh, no, we've had the talk. Okay. If it's not in writing and in a will or in a trust on a beneficiary card, I tell clients it's not going to happen. Next topic, common misconceptions. Wills avoid probate. I hear this regularly. Well, I have a will, or mom or dad had a will who's passed away, and I thought that avoided probate. No, a will is filed with the court, and you go through the probate process, which gets the assets from the deceased person to the beneficiaries under the will. That's all probate is when you have a will. If you have intestacy, that means no will. It takes the assets from the deceased person and gives them to the heirs at law as defined under Kansas law. It's not avoiding probate. For some people is the goal. I don't think it should necessarily be the goal. Avoiding intestacy, dying without a will, should be a goal.
So does having a will filed just mean you're doing the probate process or anything?
No, that's a great question. We draft a will today that says at my death, I leave all assets to my spouse, and if they don't survive, to my 3 children. Nothing is filed with the court today. That will only becomes effective at death. It's a legal document today, but only until filed after death does it matter.
File after death,
Filed after death.
so you don't file it before you die?
Do not. Cannot. Because there's nothing, I guess maybe you could take it to the courthouse and give it to somebody. I don't even know. Don't do that. Because I don't. Remember, this is not legal advice. This is just a presentation. But you might change.
Little disclaimer.
You might change your will. Clients have changed their wills. Times change. But the last will that you signed is the will that's filed after death, and it goes through the probate process.
And there is a certain amount of time you have to file, either for probate or for record.
6 months.
So if you have a will, who knows where, I thought that it was filed with the county or something,
It's filed with the court after
With
death.
with the court.
So
So if
you're,
you have a will,
If I may,
if
you
nobody
will
files it, then you don't,
let
there's no will.
let somebody know where it is. As a guy that just went through this with my father, please
tell
tell
somebody,
somebody where your will is.
please tell somebody where your will is. Yes. I have clients today I did estate planning with them 10 years ago, and they say, Jeremy, let's have a checkup. Come in the office. I say, do you know where your will is? Nope. And they say, don't you have it, Jeremy? And I say, nope, we don't keep original wills. Some law firms used to. Some law firms, I think, still do. My law firm and most lawyers I know of do not keep original wills. We give it to you. We say, put it in a safe place. So maybe put it in a safety deposit box, but tell somebody. Yes, going through piles of paper looking for a will, that's not uncommon. All property passes under a will or trust. Also, yes, sir.
And it needs to be paper form, not electronic then.
Under current law, yes.
Okay.
There,
That was a
there,
tricky answer.
so there is a, I don't think Kansas has adopted it yet, but there is an electronic, there is a move towards electronic wills. As it currently stands under Kansas law, you need to, it's not a must, but you need to have the original will in paper to file. There are, as you might guess, there are many exceptions. I have filed copies of wills, but you have to go through a different process to get approved. It's a pain. I keep an electronic copy of my client's wills, but I do not keep originals. And there's a move toward, I mean, we have electronic notarization now. There's a move to that. So a trust, you don't necessarily need an original trust, but I have documents that refer to a trust. So if there's a document that says, hey, pay all proceeds of this account to the Jeremy Graber Trust dated February 1st, 2014. What if that document is not found? I've dealt with that issue before. We can't find the trust, but that account says the Jeremy Graber Trust. So who gets the assets? So we are dealing with that. That's an area of the law that we are dealing with. Next misconception, all property passes under the will or trust. Not true. Remember, if it's joint tenancy or has a beneficiary form, it's going to follow those. The family will just take care of it. I've heard this a billion times. We've talked about it. I'm leaving it all to the oldest child and they're going to do what's right. Okay. I tell people that's fine. I trust your family won't be like any of the other families I've dealt with that's had a fight. But let's just say maybe they don't take care of it. Let's put it on paper. So my last slide here is just a few things that I've seen through the years that people don't quite understand. A joint owner versus an authorized signer. Dad's getting older, wants to name one of the kids, bank, help pay the bills. Go down to the bank, you have the very nice 19-year-old teller, and you tell the 19-year-old teller, hey, I want to put my son Jeremy on the account to help pay the bills. The teller pulls out the form, everyone signs it, and away you go. Jeremy's on the account. Okay? Am I a joint owner or am I an authorized signer? Because if I'm a joint owner and dad dies, I get all of it. Notwithstanding what the will says, the trust says, or anything else. And my brother and sister are screwed. They don't get it. If I'm an authorized signer, I can write checks for dad, but I don't get that account at his death. Sometimes, the next bullet, we try, in my firm, sometimes depending on the client, we try to account for that. We include a provision that says, I want all of my collective assets, however titled, to go to my 3 children when I'm dead. So if there is an account that has only one of my children on it, I want them to be treated as an advancement because at the end of the day, I want them to be treated equally. So you can sometimes get these pieces to coordinate together if you want. Predeceased children and beneficiaries are very challenging. If you have a piece of land that says, pay on or transfer on death to my son, what if the son predeceases? This is a hard topic for parents to often discuss because it's often met with, well, that just won't happen. Order of death is one of the challenging things. And if you're working with a lawyer and they keep asking you these questions, well, what if the plane goes down and everyone's on it? What do you want to have happen? These things do come up in our experience. So that's why we ask. Next, every year you've been given $5,000 to the charity and now you're disabled. And do you want that person to continue giving $5,000 a year to charity? Your power of attorney needs to say so, or else they can't. They typically can't make gifts unless it's explicitly stated in the power of attorney form. And the same for a trust. So if you are consistently making gifts to charity, make sure your documents allow that if you are not able to continue making gifts. Any questions? I was expecting a hot crowd. You guys were pretty tame. Well, I'm going to stop talking there. This is, like I said, this is very interesting to me, but I don't want to take up more of your time. I'll turn it back over to Vince. Anyone?
We have living will or the necessity. Should that be given to our primary care physician or kept somewhere? Or some states required to be filed with medical records?
You should give it to your physician or your health system. If you're a Stormont here, you should give it to Cotton O'Neill or Stormont. And you should probably give a copy to your spouse, of course, but also maybe your children.
Keep the original.
Keep the original.
Next of kin should know what you want and have access to it. And as for a DNR, as an ex-EMT, want it on the wall of your bedroom.
Okay.
Yes.
I've heard a term called a lifetime deed. Is that something here in Kansas?
Lifetime deed. I've heard there's a term called a life estate where I give my asset to Charlie for life, and then at Charlie's death, it goes to Susie. That's called a life estate. I haven't heard a term lifetime deed before. Any of the other folks?
Okay, what was the other term?
A life estate.
Life estate.
Don't do it. Don't do a life estate. If you go Google it, don't, that it really binds up the real estate. There are other mechanisms, including a trust, to carry out that in a more flexible manner. There's lots of things the law gives lots of options and flexibility, but it can make things far more complicated and has unintended consequences. A lot of these non-probate, these pay on death, transfer on death, and beneficiary designations are fantastic. They're simple, they're easy. That comes with the downfall. They're easy to change. You can roll up, whoever picks up mom last and takes her to the bank and gets her to change the beneficiary form to that child wins. There's nobody.
That happens a lot.
All the time. And there's no lawyer interfacing to say, Mom, are you sure you want to do this? You've had your kids as the beneficiaries for the last 40 years. Why is X getting everything today? I don't know. They just drove me down here today. That is a significant issue we are seeing in our profession of beneficiary cards being changed last minute. I said, well, Jeremy, that's wrong. Can't you fight that? Yes, but guess what you have to do? Hire a lawyer. They're expensive. So they're a great tool, but they're sometimes easily abused. Other questions?
Sure, it's specific to each case, but get an idea of broad numbers on setting up a trust. And is there yearly maintenance involved with keeping a trust?
You're talking about cost?
Yeah.
So setup, I will say anywhere from, I don't know, all the way up to $4,000 or $5,000. An easy one, I often quote people round numbers between $2,000 and $3,000. And I think I'm kind of middle of the road. The cost for a trust, you set up the trust, then you have to fund it, which means you have to retitle assets. It can't just be the Jeremy Graber name on the bank card. It needs to be the Jeremy Graber Trust. Once you do that work, that trust funding is what takes the most time after the trust is established and is the most frustrating. You all know how hard it is to set up a bank account, right? 14 layers of authentication, and they almost need a blood sample anymore. You're setting up a trust, you kind of got to go through that process. Once it's done, there is no yearly maintenance. I mean, I tell people every 5 years or a significant life event, you might think about dusting that off and talking to a lawyer. Whether you have a trust or just a basic will is my typical comments there. I love to see my clients all the time. It's not always necessary.
Well, appreciate it, Jeremy.
No.
Let's give Jeremy a little.
He's not
Go
done.
ahead. You better, yeah, we gotta get all the questions in.
First of
Oh,
all,
boy.
how do you have the beneficiary of the house?
To the house,
Yeah, it's in joint when you
You-
signed
you-
all your papers, whenever you bought the house.
so
Whoever lives.
you can do a trust.
No,
Then it will go, then you have a will. You and your spouse have a will. Whoever dies last, their will control the house and it will go through probate. Alternatively, you can add a TOD, transfer on death deed. That says after the death of me and my spouse, the house goes to A, B, and C. Do I encourage that? I don't like to do that.
okay, why?
Because remember the first, one of these slides that says spouses. So you leave the house to the 3 kids. Presumably at the time of death, they're all adults and married. So now we have the family home and we need 6 people to sign it. It's very emotional. And this child doesn't want to sell it and maybe wants to rehab it for a verbo. This child is so distraught, they don't know what to do. This child is an accountant who lives in Boston that says, sell it yesterday. So what do? They're all 3 owners with their spouses. And the spouses are all in their ear. Your sister's getting more than you. And so I just don't like that.
So you don't like TOD on the house for that reason.
Correct?
So if you put it in the will and it says go to the 3 kids,
The executor can sell it. And the executor is my practice. Other people have different approaches. I like one executor. We don't have 3 co-executors, we have 1. And that person can sell that house. And if the other 2 want to whine and complain, you can go file your stuff with the court, but the executor has the authority to sell,
To settle the estate.
to settle the estate.
and if you have this is question number 2. If you have all of your accounts and everything, TOD, beneficiary, etc., the purpose the will is actually serving is for anything left over,
Yes,
basically.
correct. Anything that's missed.
Or that was less ideal, that you didn't want to do a TOD for, like the house in your example.
Correct. It's a backstop.
Sometimes that happens. Give a real life example. We were handling, I was with the bank, we were handling a trust in the estate for an individual. He had everything in his trust, spouse, predeceased, no children. So he had his will, we filed a record. And then about a year later, I got a call from an attorney out in western Kansas. Well, this gentleman who was in his 80s when he passed away, his mother's estate had been opened and never settled. He was entitled to 7 sections of land. So we trotted down to the courthouse, pulled out the will, got probate going and took care of it and disposed of it as he indicated. So, sometimes, now, did he know he had that? I assume he did, but he sure never thought about it.
Right. When we have trust, when we do trusts, there's a reference in here to a pour over will. And so when we do a trust, we want everything titled in the trust. Sometimes something is missed. I got a phone call 2 weeks ago from a bank I do some work with. A husband and wife, they had everything in trust. Wife died a couple years ago, husband just passed away. Great, they got the trust going, we got things figured out. Life insurance policy. Spouse was named as beneficiary and no backup. So we're gonna have, it's a $100,000 policy, so we're gonna have to probate a $100,000 insurance policy, file the will. That policy, we have to wait a little bit, but that policy is gonna drop into the trust and be dispersed as they wished. So you're right, it's the will, even whether you're doing trust planning or you have all these beneficiary designations, it's a backstop at the least.
No, I said I had two. Those were my two.
Okay. Well, thanks to Jeremy for his time. For those of you who came in a little bit later, I'm Vince Cox. I'm the chair of the endowment committee for the Jayhawk Area Council. And I just want to put in a quick plug for our endowment. Of course, the endowment for our council has been extremely important to make sure we have scouting programs in Northeast Kansas, and it's going to continue to be important. And vitally important that we get unrestricted gifts so we can make sure to keep putting on our programming. And I guess for the purposes of Jeremy's presentation tonight, the important thing to know is we can facilitate receiving gifts all the different ways, during your lifetime or after your death that Jeremy's talked about. So, and for lifetime gifting, there's all different ways that, we honor people that give to our endowment through things like the James E. West Fellowship. Those are people that give $1,000 gift during their lifetime. And then there's honors up and above that. But the whole point is to know we're here, the endowment is important for scouting in our area. And we're here to facilitate any lifetime or after death gifts that people might be interested in giving. So that was just a little plug I wanted to give for the end of our presentation, but I'm glad everybody got some good education from Jeremy tonight. So,
Thank you.
Thank you all.
That's all I have.
That's all right. Let's see.